May I have your lordship's kind leave to mention a matter, my lord? This is a group 9 appeal, my lord.
Monday.
A new appeal, my lord.
New appeal is inclusion upgradation on Monday.
This is for inclusion.
I am it is an appeal of a third party against an order which has been made. I won't get a certified copy. Leave to file without a certified copy, my lord.
Any urgency, extreme urgency?
Urgency, my lord, is that a particular entry in the excise rules have been deleted and my stocks worth of lakhs are being there without me being able to sell it.
Certified copy. You get a certified copy in file.
But I am a third party, my lord. I will not be given a certified copy. I am a third party to the writ.
So you want leave to file?
Leave to file an appeal?
Or leave to file, yes.
May I have your lordship's kind leave to mention a matter? This is for listing of an appeal, lordship. It's a fresh matter.
Fresh matter, please.
Grateful.
Yes.
My lord, unusual prayer upgradation, my lord. I have been waiting for 4 years.
4 years.
My lord. My lord, it is of 2020. It is appearing in the list. My lord, what the British ruler did, even after 80 years, several lakhs of people.
Let us see.
India have no direct connection of Calcutta, my lord.
My lord, may I have your lordship's leave to mention a matter, my lord, for correction of your lordship's order?
What is the mistake?
The mistake, my lord, some appeal numbers have not gone down in the order. My lordship remembers, this is the Damodar Valley Corporation appeals. The consumers had preferred a batch of appeals and the Damodar Valley Corporation had also. Lordship had directed, my lord, so far as the consumers' electricity has been disconnected, lordship had ordered restoration of those consumers. My lord, the appeal numbers, my lord, I appear in one of the appeals by the consumers, but that appeal has not been mentioned and the Damodar Valley Corporation is refusing to restore the electricity connection. I've given notice. These are the orders, my lord, in the.
No, if this appeal was also there, we can make include.
Yes, it was there, my lord. It was there.
Show it in days list, supplementary list.
Hello.
Please take down. By order dated, please give the order. By order dated 19/4/2023, we had issued certain directions. It is submitted by the learned advocate appearing for the appellant in your
My lord, MAT number 436 of 2023.
2023. Though the matter was in the list, the order does not include the said appeal. This being an inadvertent mistake, the appeal in MAT number so and so shall also be included in the order dated 19/4/2023, and whatever benefits have been granted to the other assessees who are the appellants, the same shall renew in favor of the appellant in MAT number so and so.
Only thing is that my lordship kindly takes from the first page of the order. My lord, our appeal is appearing. MAT 436 is this is the second one. If your lordship sees, MAT 436. But lordship kindly takes paragraph 11.
In that it is not included.
Yes, my lord, that is.
Though the said appeal has been shown in the preamble of the order, in paragraph 11 of the order, the appeal number has not been included. This being an inadvertent mistake, in paragraph 11 of the order dated 19/4/2023, MAT number 436 of 2023 shall also be included, and the Damodar Valley Corporation is directed to restore the service connection of the said appellant as well. This order shall form part of the order dated 19.
I'm so grateful.
Yes. Please call the list.
Lordship, under compelling circumstances, I am forced to mention a group 4 matter here, Lordship, the revenue matter. Already 90% of the money tax demanded has been taken. Still, they are continuing with the garnishee. I cannot continue my business here, Lordship.
Is it a fresh matter or
fresh matter? Fresh matter.
Fresh matter, you please.
Lordship, this.
Your Lordship, may I be permitted to mention a matter for inclusion in the list? This is
Monday.
So this is a very important so moto move. So the thing is that the banks a year back, they had put systems in new cars, a tracking system, which the RBI fined 10 crores rupees to them.
We can't take it up so moto, sir.
So the thing is that they're now puncturing the tire with the medical syringe around the new High Court.
You file a petition.
I've already filed. I've already filed it. This is. I just want to mention that.
Yes, thank you.
Appellate side daily list under the heading for judgment, item number 1 to 4.
We'll just read the operative portion. In the result, the writ petitions are disposed of by directing the concerned police to ensure that all the FIR's documents, material seized, CCTV footage, etc., be immediately handed over to the appropriate authority of the National Investigation Agency, who, on receipt of all the entire material, shall commence investigation and proceed in accordance with law. The respondent police are directed to comply with the direction of handing over all the material to NIA within a period of 2 weeks from the date of receipt of the server copy of this order.
Grateful, my lord.
I beg to appear on behalf of the NIA, my lord. My lord,
Yes.
I tender my apology, my lord, for fever, my lord. I am appearing virtually.
No. Take
my lord,
care.
My lord, only one thing, my lord. My lord, in terms of the provisions of Section 6 of the National Investigating Agency Act, my lord, it has to be sent to the central government. And the central government thereafter forwards it to the NIA, my lord.
That is also there.
I'm grateful to your lordship. Grateful.
Deeply obliged.
In fact, we'll read. Therefore, we are convinced that there is also mention about the acid bottles, and if be so, necessarily offense under the Scheduled Act have been committed. The procedure under Section 6(1) of the NI Act should have been resorted to. Therefore, we are convinced that no useful purpose would be served by directing the state police to register cases under the Explosive Substance Act or any other Scheduled Act, as the matter has traveled beyond the said stage and is a fit case that the entire investigation should be transferred to the NIA with a direction to the central government to exercise their power under Section 6, subsection 5 of the NIA Act.
I'm extremely grateful to your lordship. My lord.
I'm grateful, Lordship.
My lord.
Pardon?
May go through the judgment once.
We'll upload it.
Specially fixed matter. Item number 5,
My lord, I appear on behalf of the respondent petitioner. Yesterday, I mentioned the matter. Lordships were kind enough to upgrade it. I tell your lordship, my lord, the facts, what compelled me to take out the scan application. My
You
lord,
said some check you are holding.
yes, absolutely. I tell your lordship, my lord, the facts, my lord, in the year 2014.
My appeal.
No, no, your appeal,
My
but it's
appeal.
my application.
No. He mentioned this.
He
scan.
mentioned the matter, your lordship has accepted it and fixed the matter today for hearing.
So kindly permit me to
No,
place this
we-
application.
We didn't know what is this scan
Yes.
application.
Right.
Because we directed the Learned Council to give notice to your.
I'll
Yes, absolutely.
And
May I, my lord, tell your lordship, my lord, the facts in 2 minutes before I show you the order. My lord, in the year 2004, my lord, an auction sale was conducted by the appellant herein, who is the Central Bank of India. I participated in the auction sale and paid rupees 35 lakhs a odd. That was in 2014. Now, my lord, even in 2022, in spite of indicating in the sale notice that the possession was with the bank could not hand over possession. That compelled me to come before this honorable court by filing an application under 226 of the Constitution of India. Now, my lord, after filing this writ application, an interim order was passed upon being satisfied about the prima facie case that I had made out, directing the bank to deposit the entire amount which I paid along with the interest of 10%. That they did, which comes to about 65 lakhs. Then what they did, my lord, after this order was passed, they filed a writ application contending that the failure on their part was because of the negligence and laches on the part of the district magistrate that he could not hand over the possession. But there was no such term in the sale notice. They say the possession was with them. Now, in that scenario, my lord, the writ petitions were heard by the learned trial court, taking both the writs together because one is connected with the other. And by a final order, my lord, passed an order directing the registrar who was holding the money in terms of the first interim order to, my lord, hand over the money. In between that, my lord, I filed an application before the first court saying that I am in dire straits. I don't have any money. 8 years have gone. Today, the purpose for which, my lord, I paid the money that has gone, kindly return the money. And that was also a prayer in the writ petition. So that was allowed. Then, my lord, they preferred an appeal. They preferred two appeals on identical ground because one writ petition was filed in the original site and the other one, their writ petition, saying that because of the laches and negligence on the part of the district magistrate, that was filed in the appellate site. So both were tagged together. So they preferred to appeal, challenging the same order because one is an original site, the other one an appellate site. Now, my lord, when the appeal preferred, my lord, appeal was initially heard, my lord, for 2-3 days as new application. And, my lord, I candidly submitted before the court that check was handed over to me pursuant to the direction of the trial court because there was no stay. I got the check, but I candidly submitted why I am not depositing the check because the litigation is pending. That happened in January, my lord. Today we are in the month of April. Validity of the check, lordship knows it's about 90 days only. So the date expires on, my lord, 30th of April. So I filed this application, the CAN application, saying kindly, my lord, permit me to deposit the check in the bank with an undertaking that I will not take away the money till the appeal is heard or finally disposed of. That's my prayer in the CAN application. Alternatively, my lord, subject to what falls from my lords, I say it's a very short point involved. Whether the bank can unreasonably and wrongfully and illegally withhold the money even after their failure to hand over the possession.
So now if the money is with the bank, it will be safe.
Money is not with the bank. Money is presently with the registrar pursuant to an interim order.
It's a check.
Check. Now, my lord, check was handed over to me pursuant to the direction. Kindly come to the orders, my lord, once. I have all annexed in my application.
No,
That will make the position clear, my lord.
Annexure P4 is the check.
Annexure P4 is the check,
Check.
my lord,
Now
30th January.
you are holding the check.
I am holding the check, but I am not presenting it because I gave an undertaking to the court that I will not present it. Now, my lord, kindly come to the first order, page 12.
We can do one thing. We can ask them to replace the check with a fresh check so that you get another 3 months and fix the appeal for
any day, or else, my lord, or else, yes, lordship can do that.
that will be fine.
Lordship.
Or one other thing can be done. This you deposit this check in the appellant bank and it will be held as a separate escrow account,
My lord,
subject to the outcome of.
my lord, then that will be, my lord, contrary to, my lord, the orders passed by this court. I tell your lordship. Kindly come to page 12.
Then for the present, what we can do is we will direct the appellant bank as on 30th of May, 30th of April, you issue a fresh check. And with the same undertaking, he will hold the check.
May I submit one thing?
My lord, money is with the registrar. Kindly come to page 12 once, the interim.
So they will issue a fresh check, but
So what I can do, my lord, I can hand over the check to the registrar. Money is not with them. They have, my lord, given the entire money to the registrar. Kindly come to page 12 once. That was the interim order passed in the writ petition.
So the registrar.
Register in turn, my lord, handed over the money check.
Registrar original side will issue a fresh check
Yes, that lord.
on the expiry of 30th of April.
Absolutely.
one
And
submission
clear out
I
the
have,
appeal
Lord.
any day. It's a very short point, my lord.
You said it was
It's
heard for
when-
3 days.
My lord,
We can't hear.
my lord.
No, we heard you saying that the appeal was heard for 3 days at the admission stage.
My lord, I tell your lordship, my lord, the point.
Because we don't want to get caught in that. There are a lot of
Only
other-
one submission I have.
Otherwise, I will never get the money. I may hold the
No,
check.
no.
And what is my fault? I paid it to a nationalized bank.
If my learned friend's client will get the money, my lord, they will flit away.
No,
will
then
be
your appeal will become infructuous.
Yes.
So-
And public money, my lord, public person will
But
take
then,
and
that's true, sir. Maybe public money. He has participated in the auction,
not that will,
sold the property.
that is the merits of the appeal, my
He
lord, I
has
will
paid
face.
the money. You are not able to deliver possession.
I have, I have,
You have.
my lord, I have, I will show to your lordship.
Then
That's why, my lord,
Not
there's the
today,
appeal.
not today.
Not only one submission I have. Not so far the order of the honorable single judge is concerned, my lord, that no writ petition was decided by the honorable single judge. Only a can application filed by my learned friend, my lord, was decided, and on the basis of that, my lord, the honorable single judge has directed, my lord, the register to hand over the check. Within 2 days, we preferred the appeal. My lord, we placed the appeal. In the meantime, my lord, what they have done to pressurize the court, my lord, they have obtained the, my lord, check from the register itself. And since, my lord, the appeal was in season, of hearing, my lord, what they have submitted, your lordship kindly available of the page 38. This is the order passed by the division bench of this honorable court
Learned
on
counsel
the
for-
2nd February.
No, wait. Learned counsel for the private respondent is informed that the check of requisite amount has been handed over by the concerned registrar to the private respondent. But he has
At their
instructed
instant,
the
they have
private
received.
respondent not to deposit the check in the bank for encashment. This has also been stated by the counsel for the private respondent on instructions who's present in court. Then seeks time with the material and judgment supposing proposition of law. At request of the appellant adjourned. So today we will say
Your lordship kindly have a look of the 2nd February 2023's order.
we can't vary this order.
Very well. Lord. I don't have any problem, my lord. Let them return the check to the register.
And
Let the appeal be heard. Let the appeal be heard.
he will return the check to the registrar.
And
the
register will
registrar
deposit it and fix deposit.
Registrar will issue a fresh check
Absolutely.
for the same condition with the direction that he shall not present the check. We'll fix a date for the appeal in June.
But so far
Any
the
day, I'll
further issuance of check is not required at this stage.
No, because if the check.
Because if the check is issued, my lord, then my lord,
Then-
this
then
amount
you
will
should
not
have-
be.
No, then you should have filed an appeal against the 2nd February order before the Supreme Court.
No, my lord, in this order, my lord,
No, not only that,
I
there was
get benefit of that. Because they have received the check from the register.
There was an
and
earlier
they
order.
have given undertaking that they will not encash.
My lord, kindly come.
Same-
That will
Same undertaking will continue.
Absolutely.
only one submission I have. If the check is issued by the register again, not only they will lose the interest, nothing else. This is for their interest I am submitting.
I'm ready.
This is for
I'm-
their interest I
I'm
am
ready to
submitting.
lose the
If
interest
the,
because
if the
I have
amount
lost
is
interest
deposited
for
with the register and if the register is invested with the bank, nationalized bank, they will get the interest if they succeed in the appeal.
That's a very valid suggestion. That's what we are putting it to you. What we can direct is, we can direct the amount to be held by the respondent bank. I'm
That
appellant
can be
bank.
done all.
By the registrar.
No, wait.
No,
wait,
but
sir.
bank, yes.
He is a bank. He is not a private party.
I cannot flee away.
Wait. If you
Sorry,
keep
sorry, sorry.
on coming, all four of us talk.
No, I'm
No,
sorry.
sorry.
I'm sorry.
What we'll do is, we'll direct the registrar to deposit this money in an escrow account to the credit of MAT 106 of 2023 and CAN 2 of 2023. And in that escrow account, it will be an interest bearing account. It will be retained by them and they will not appropriate that money. And subject to orders passed in this appeal, that money will keep on accruing interest. In June, we'll hear the appeal.
I'm grateful to you, Lord. I'm
It's
grateful.
a nationalized bank. It's a nationalized bank.
Yes, yes.
So money will be safe as suggested by learned counsel. It will also get interest. Instead of the registrar holding that, registrar will deposit it in the appellant bank to the credit of MAT 106. And that will be retained in an interest bearing account and will abide by the result of this appeal.
I'm grateful to you, Lord.
My lord, may I say this? May I say one thing, my lord?
It is, in fact, it will be beneficial to your client.
Absolutely. Instead of that, my lord, what I submit before your lordship because of the past conduct of the litigation, I'm not addressing you on merit anything. Kindly, my lord, direct the registrar what he did previously after the first order. He, my lord, deposited the entire money in a short-term fixed deposit. Let him do that, my lord.
Let that short-term deposit be with the appellant bank. Let them pay interest.
Yes.
Why put it in Axis Bank or ICICI Bank? Why?
No.
Let it be with the appellant.
It was done in a nationalized bank. My lord, I could have accepted this, my lord, had they been fair to me, my lord, for last 8 years.
Ultimately, if the relief you seek is against them,
Yes.
from them.
So let this be in the hand of a neutral person, and the best person is the officer of the court, my lord.
What
This is what I
purpose?
submit.
Neutral person for what
Kindly, my lord,
purpose?
kindly. Yes, of course. Yes,
Only
of
for interesting purpose.
you interrupt, then my lord would not be able to.
As your lord, as your lordship.
Let
No.
it be in the hand of a neutral person, and
I don't have any objection.
No,
I
no.
want that
Now,
interest
on
should be
what
paid.
date the registrar has deposited the money?
yes, kindly, my lord, come to, my lord, the first order, my lord, page 12.
Page?
Page, my lord, 12, the first order, first interim order. Page 13, if lordship, my lord, kindly comes to, my lord, the last two paragraphs. Page 13.
Yes.
If
Now
I may
she
read
has
out.
deposited that money
Yes, he did it.
and then issued a check in favor.
No, he deposited initially after the order of the trial court allowing my prayer. Then he handed over the check to me. And that was also the order of the appeal court to an extent. First order kindly comes to appeal court's order. He only extended the time. Kindly come to the first order of the appeal court. Page 30, not 30, page 36.
26 or 36.
First order, page 36. So what was the nature of the interim order passed, my lord? They didn't get any protection. Last sentence, considering the circumstances of the case, 1 week time given by the learned single judge in the impugned order, it was not 2 days, 1 week, for refund of the amount is extended till the next date of hearing. Time extended, I got the check and I am holding it. Let this be, my lord, I will return it to the registrar, my lord. Let this be in the hand of a neutral person, my lord. And the best person is my lord's.
Now the check will be returned.
To the registrar.
No fresh check will be issued.
No.
And the money will continue to be retained in an interest-bearing deposit.
By the registrar and kindly directed to, my lord, invest in a short term and fix a date, my lord, any day after vacation.
An application number so and so. This application has been filed by the respondent in the appeal, praying for a direction to permit the petitioner respondent to deposit check bearing number 929145 issued by the registrar, original site for a sum of rupees 63,09,851 dated 31st January 2023 in favor of the petitioner / fourth respondent in the bank account of the petitioner / fourth respondent without any prejudice to the rights and contentions of either parties, and the petitioner / fourth respondent undertakes not to withdraw the said amount from his bank account until the appeal is finally disposed of. The division bench, by order dated 2nd February 2023, had recorded the submission of the petitioner / fourth respondent that the check of requisite amount has been handed over by the concerned registrar to the petitioner / fourth respondent, but he has instructed his client not to deposit the check in the bank for encashment. And this submission was made on the instructions received by the learned counsel from his client, who was present in court on the said date. The petitioner / fourth respondent has filed this application on the ground that the check issued by the registrar, original side of this court, is dated 31st of January 2023, and by 30th of April 2023, it will lose its validity. After elaborately hearing the submissions on either side, we are of the view that the following order will protect the interest of both parties. The applicant, the petitioner / fourth respondent, is directed to return the check dated 31st January 2023 to the registrar, original side of this court, who will hold the check, and the said amount which is now lying in deposit in a nationalized bank in an interest-bearing account shall continue to be retained in an in such an account where interest will be paid, and such deposit by the registrar, original side of this court, shall abide by the orders that may be passed in this in the appeals. With the above direction, Can 2 of 2023 is disposed of.
Kindly, my lord, my lord,
Let the appeal be listed for hearing.
any day when it is convenient to the court, my lord,
Once,
at the earliest, my lord.
15th of June.
I'm grateful to your lordship.
I'm grateful to your lordship.
Yes.
My lord, may I, my lord, file the affidavit of service?
Affidavit of service
Be
taken
kept
on
ready.
record.
ঠাকুর না না ঠাকুর ঠিক আছে only one thing, my lord, since you only one thing, my lord, since we have not used any affidavit, my lord, allegations not made in the application, my lord, are denied.
No paper book is required.
No, so far this application is concerned, we have not used any affidavit to this application.
Yes, yes.
Yes, I'm grateful to you.
Item number 6.
No, কিন্তু অনেক দেরি আচ্ছা করুন হবে
Malad video service. But
I
here,
appear for the private respondent, my lord.
Malad, the petitioner number 1 is the aged about Malad 87 years, and petitioner number 2 is 80 years. Malad made written complaint before the officer in charge from 2020, Malad, against the son and daughter-in-law for physical assaultation of the petitioners. And Malad, that was Malad not taken into consideration. For that reason, 2021
But how to interfere with
Malad,
this?
only I am praying in my writ application, Malad, to investigation of my written complaint as per
There are, you
and
please,
that was
no. You
and
please
we-
advise your client. There is a separate enactment under which you can file an application. There are various remedies.
and
Yes.
Malad, without calling any report from the state authority, my writ petition has been disposed of without any direction of the state authority. Malad, I am praying my written complaint that was a Malad in specific.
No, if he has not registered a case, there are remedies available to you.
Malad, FIR has not yet any register, no investigation, nothing. Malad, there is a specific allegation
No,
against
the
physical
learned, the
assaultation.
court records that your petition or complaint is to cancel a gift deed.
No,
How-
my lord,
how
that
can
is,
the
that
police-
is not true. My lord, I am praying, my lord, that my writ application sent to the SDO that was refused. Refused by the SDO, that is page 20. The written complaint which was made by the to the OC as well as subdivisional officer, the said subdivisional officer was refused my written complaint to accept this. That was I
Who's
page
for the
20.
state?
And without calling any report, my lord, that this is, my lord, only my allegation, my FIR, written complaint, my lord, registered as a FIR, and that must be, my lord, investigated properly. But that was not investigation, and my lord.
Therefore, you file a private complaint. If he is not doing it, how to bypass this? I don't know.
My lord,
These sort of writ petitions are not maintainable.
my lord, section.
Or you go under 482, seek for a direction.
Section 20
This
specific.
intra-court
My lord,
is directed against the order dated so and so and WP number so and so. The dispute as focused by the petitioner appellant in the writ petition is a private dispute with regard to a property which appears to have been gifted. And the ultimate grievance of the appellant writ petitioner is for cancellation of such a gift deed. Therefore, the learned writ court had rightly declined to entertain the writ petition, and we find no grounds to interfere with the said order. However, we make it clear that in the event the respondent police have not registered a case, we grant liberty to the appellant to invoke the other remedies which are available to them under the Code of Criminal Procedure. With the above observation, writ application dismissed. Next.
Item number 7.
Please, your lordship, I appear for the respondent writ petitions.
Now, the writ petition has been filed, my lord, basically by a person, my lord, rather than a power button holder, but who do not have, my lord, the possession of the land, and by using the writ course order, my lord,
Appeal application.
writ course order, my lord, and by using fluid force, my lord, they are trying to, my lord, get into the possession, my lord. That's my challenge, my lord. My lord, kindly, my lord,
Police can't put him in possession.
No.
that's my point. That is the only point I have, my lord. Kindly see, my lord, the previously they have approached the revision bench, my lord, in 2011. Then what they'll kept silent. If you say kindly turns to, my lord, the division bench previous order, my lord, at page 50. This is can number 2, my lord. 50. This is
No,
the
there is a reference to some order passed in MP case number.
that is, my
740.
lord, that is, my lord, proceeding under section 144, and thereafter, my lord, they approached, my lord, this writ court dismissed the writ petition. They approached division bench in 2012. The order is at page 50, my lord. But there was no direction. My
Who
lord,
are they? They are not the private respondents in the writ petition. They are ranked, they have to explain to your lordship.
Not 50.
Yeah.
I'm explaining. Not 50. This is the order passed by, my lord, honorable division bench.
No, division bench said that the
Maintain
respondent
peace.
officer in charge, so and so police station, to see that no breach of peace takes place in and around the area in question. Afford the direction, we set aside the impugned order and appeal passed by the single judge, dispose of both the applications. Yes.
But I had no difficulty.
I
In
also
2000
don't have any difficulty.
2012, and my lord, in MP case filed by them, my lord, there was a report filed by the authority, my lord. The report says I am in possession, and he is saying that who I am. My lord, I am the person who is cultivating the land, my lord, years together, my lord.
You cultivate,
Now, my lord, page 53.
you give a counter complaint.
My lord, page 53.
If he is interfering with your possession, you give a counter complaint.
My lord, kindly record that.
This intra-court appeal is directed against the order dated so.
The leave to appeal application, I am taking an objection, formal objection.
All right.
Kindly record.
The appellant is a third party to the proceedings and has sought leave to file this appeal. The learned advocate appearing for the respondent writ petitioner would vehemently oppose such a prayer. However, on going through the impugned order, we find that the matter concerns an immovable property, and the ultimate issue would be who is in possession of the property. The third party appellant claims that he is in possession of the property, which is denied by the respondent writ petitioner. In any event, the police authorities cannot examine the question of title or possession as claimed by both parties. And all that they can do is to ensure that law and order is not disturbed in the locality on account of the dispute between the third party appellant and the writ petitioner. In fact, the division bench of this court, in an earlier round of litigation at the instance of the respondent writ petitioner in MAT number 1752 of 2011, had passed an order on 6th March 2012, directing the officer in charge, Pandua, P-A-N-D-U-A police station, to see that no breach of peace takes place in and around the area in question under any circumstances. With the above observations, the order passed by the learned single bench in the writ petition was set aside and the matter and the appeal was disposed of. Therefore, if at all the appellant apprehends that the respondent writ petitioner would dispose him by using police force, it is well open to the appellant writ petitioner to give a counter complaint. And if a complaint is given, then the respondent police shall inquire into the matter as a case and counter and proceed in accordance with law. With the above observation, appeal stands disposed of. Next.
Item number 8.
Grateful, dear Lord.
Yes, sir.
Writ petition.
I have served even the learned advocate who appeared in the court below personally.
Now, what is this problem?
The appeal is by the writ petitioner was the mother against me. Mother against me. I am one of the son. The other son and daughter stays on the first floor with the mother. I stay at the ground floor. Everything is separate. My portion is separately grilled and it's separate. But I say, and it is a fact that at the instance of my brother and sister, mother had preferred this, saying that I have to be ousted. Unless that I am ousted, they cannot get hold of the entire property. They want to grab the entire property by somehow provoking my mother. If this writ petition has been used as a civil remedy for evicting me, but it has, they have somewhat been successful in saying that I have to evict by 30th of April. This has been used as a civil remedy for eviction. Most probably in my humble submission, it is probably.
But you are not heard in the matter.
I was heard. I was heard.
Then the court says respondent number 8, that's your client, shall be entitled to stay on the ground floor of the writ petitioner's residence
30th April.
3 months.
Yes.
Undertakes before this court not to disturb the mother.
Yes, I shall not.
You will not. Then
the only thing which persuaded the court, and the only thing which I believe persuaded the court that I work in police force.
And he is a police officer.
Yes, I work in police force. This may have persuaded the court that I may be somewhat interfering with the investigation, or maybe, but I work under West Bengal police and this is under Kolkata police. The area is completely different.
No, the court says that you can apply to the
yes, that is always
third
open.
battalion,
But
and
that probably in my humble way, writ court cannot go into. In their writ petition, my lord, in my humble understanding, probably.
But why your client is fighting with his mother?
No, my client is not. If your lordship invites the mother to come and directly speak to you, even in chamber, she will say that I am not even trying to evict my this son.
His brother is trying to use.
His brother and sister. They want to grab the entire property and somehow instigate the mother to transfer it on their behalf.
Sad.
Mother is staying with them, and on my earning, the entire family runs, and it will run on my earning.
And what is the brother doing? He is also
Nothing. He is a local, I would say, gunda or something.
We have heard the learned
there is a 30 days
the appellant. Though notice has been served and affidavit of service has been filed, none appears for the respondent. On going through the order passed in the writ petition, we find that essentially there is a dispute between the writ petitioner, her and the appellant, who's one of her son, and there is another son and daughter who are stated to be residing along with the writ petitioner in the first floor of the building in question. The appellant is stated to be residing in the ground floor. The order and direction issued in the writ petition directs the appellant to stay in the ground floor of the premises only for a period of 3 months, which is to expire shortly. Prima facie, we are of the view that the grievance is expressed by the writ petitioner is a civil dispute in which the writ court would seldom interfere. Therefore, there will be an order of interim stay of the order dated 31st January 2023 till the disposal of this appeal. Let fresh notice be served on the or we can dispose of. You have served notice on the.
Yes. I have served notice upon the advocate, upon the learned advocate appearing for the mother at the trials court. He has personally received.
Till the disposal of the appeal. Let fresh notice be served by the appellant on the respondent writ petitioners. In the meantime, the undertaking given by the appellant before the learned writ court that he shall not disturb his mother shall continue. List the appeal during third week of June 2020.
My lord, only one thing, my lord, there is a delay that has to.
How many days delay?
30.
First paragraph, we have heard the learned advocate so and so, same thing. Affidavit service filed and appeals. There is a delay of 30 days in filing the appeal. We have perused the affidavit filed in support of the application and we find sufficient cause has been shown for not preferring the appeal within the period of limitation. Accordingly, application is allowed and the delay in filing the appeal is condoned.
I tried to settle in the meantime with my mother, talk to her. That is the reason for the delay.
But one son is a policeman, another person is a gunda.
Item number 9. My lord, while dictating, it may have gone down as 3 weeks instead of 3 months. The last, my lord,
It should be 3 months.
Within 3 months, it may have gone down as 3 weeks. May have. It will be 3 months.
3 weeks, it will be 3 months. It is to expire short.
Yes. Marshal.
Item number 9.
Lordship, I am appearing on behalf of the appellants.
I beg to appear for the state respondent, Lordship.
The writ petitioners at the appellants hearing. Well, both of them are senior citizens, aged about 70 and 72 years respectively. Well, they are the joint owners of the property measuring about 15 kathas lying under Moja, Brahmapur, PS Basdroni, Kolkata. In the month of January 23, they attempted to construct boundary wall, but they were obstructed by the land mafias or land brokers in the locality. For the reason they made written complaint at Basdroni police station, praying for police help upon payment of cost if necessary. So steps had been taken. Then they made the complaint before the superintendent of police on the same prayer. That was not considered. Then they come with a writ petition before this honorable court. Your lordship kindly have a look at page 110, the impugn order passed by the learned judge.
We saw. Learned judge says suit is
Learned judge says,
suit is
first, why the writ petition appeared at the heading senior citizen matter. And second thing is that.
No, he is 72 years old.
Lordship.
Your client is 72 years.
70 and 72, two appellants. But the learned trial judge, it was filed, it was listed, due to urgency, it was mentioned to appear at the heading.
No, it's a senior citizen matter.
Lordship. Then my lord says that why this matter appeared at the heading senior citizen, first question. And second is that a title appeal for the year 1997 is pending before the learned civil judge Alipur. But it is not correct because the civil suit disposed of in 1999. I have annexed the judgment. So my lord, the two scores are not correct.
Lordship, may I just respectfully submit?
Just can you hear
the
us?
learned single judges?
Can you hear us for a minute?
Lordship.
If a cognizable offense has been committed, or if he files a complaint, you inquire into it. If it's a mistake of fact, or if it is a civil nature, you dispose it off. Because of your inaction, the residuary bench is being overburdened with all these sort of writ petitions.
Lordship, may I just request your Lordship Miller to come to the Millard the prayer in the writ petition. Writ petition has not been annexed to the stay application. Millard, kindly Millard, prayer is to assist police help to the petitioner for construction of a boundary wall.
That will reject.
That is the prayer in the writ petition. Of their lands upon payment. In the writ petition, Millard, they are, Lordship has been handed over the copy of the writ petition.
Yes, please.
There is one complaint, Millard, before the police that is annexed at page 49, where he says the heading of the complaint is complaint against illegal activity of the person named Sandeep Ghosh Dostida. He is disturbing their constructional part. We inquired into the matter. Sandeep, he is not implicated in the party, Miller, as a party respondent in the writ petition. We inquired into the matter. Sandeep says that with my father, with their predecessors, there was a title suit, there was a title appeal.
Therefore, close the complaint as mistake of fact or close it as civil nature.
His prayer is to render police assistance when he will be constructing his boundary wall. That is the only prayer.
No, you have inquired into the complaint. You have not disposed of the complaint.
No,
You-
lordship, usually in the case of civil issue, sir, the usually rendering of police assistance is given only when there is court's order.
If you,
He is asking, my lord.
if you are refusing to understand what we want to
No,
explain.
lordship,
There is a complaint. You have inquired into it. It's purely of civil nature. You refer the complaint as mistake of fact or of civil nature. Let him go and break his head elsewhere.
lordship.
He should be intimated.
And my lord, regarding this cost part, which my learned friend is saying, despite the matter being a senior citizen, since the learned single judge is not before your lordship to represent, context was this, that since the honorable court is otherwise overloaded, so an opportunity is being given to the learned lawyers that wherever the senior citizen matter involves a question of Article 21, I am giving you the liberty to mention the matter, automatically it will get upgraded.
He says
That opportunity was given to him.
no, he says his life and liberty is affected because compound wall could not.
So when the matter was taken up, honorable judge sees that it is not a question of Article 21, it relates to property. That's why lordship was.
All right, imposition of cost is between the court and the petitioner.
No, the context of the situation was not that.
This intra-court appeal by the writ petitioner is directed against the order dated 22nd March 2023 in WPA 3544 of 2023. The writ petitioner sought for protection from the respondent police for the purpose of putting up of a boundary wall. Such a relief could not have been. Such a relief in a petition under Article 226 of the Constitution is not maintainable. Therefore, the learned single bench was right in not granting any relief in the writ petition. It is pointed out by the learned advocate for the appellant that the civil proceedings are no longer pending and the title appeal in TA 37 of 1997 was disposed of in the year 1999. The learned counsel appearing for the state pointed out that the prayer sought for in the writ petition is for the purpose of putting up a boundary wall. And the police have inquired into the matter and found the matter to be of civil nature. Thus, no relief can be granted to the writ petitioner and the appeal has to be dismissed. However, with regard to imposition of cost is concerned, the learned single bench is right in stating that the matter is not affecting the rights of a senior citizen under Article 21 of the Constitution to get a precedence in the hearing, as the matter concerns an immovable property. However, considering the fact that the appellants are aged more than 70 years, we delete the cost which has been imposed on the appellants. Accordingly, the appeal is dismissed. Liberty is granted to the appellant to work out the remedy in the manner known to law. Next.
Item number 10.
Yes.
I'm for respondent number 2 to 7, Madam. I tender my unconditional apology, Madam. Yesterday I was not present.
No problem.
I initially, started what I was going to argue, principle on points of law, on the principle of acquiescence, waiver, and approbate and reprobate. Why I say this, may I in brief, narrate the facts, what has happened, the writ petitioner is one of the partners of a gas station maintained and managed by Bharat Petroleum. Bharat Petroleum is the owner of the land, the licensor, and they are the licensee. So they were managing. The writ petitioner's mother and the writ petitioner, was approached by the private respondents that the business is not doing well. So why don't you come to us? Let us form a partnership. Let us run the petrol pump. Partnership was formed way back in 2015. Thereafter, the pump ran till 2022. It's still in a running condition. It's not stopped, it's still in a running condition. In 2022, In the meantime, my lord, payments are cyclic payments have to be done to Bharat Petroleum. They will issue, my lord, receipt of those payments, my lord, because of an indents has to be sent for refilling the contained tankers and all. Everything is under process, my lord. In the meantime, my lord, Bharat Petroleum refused to accept one of our checks, saying that you are not a DPCL signatory, which entails you to issue checks. Since 2015 to 2022, checks were received, payments were done, business was, it was all hunky-dory, my lord. There was no problem at all. When the check was stopped, the writ petitioner approached the writ court at the first instance. The writ court, my lord, without going into the merits of the matter, said that very well, there's a guideline, policy guideline of Bharat Petroleum. So you go before the authority, discuss the grievances, settle it out. Writ petition was sent back to the authority. Representations were made before the authority. Then the authority says that under the guideline, there is a specific provision. If a new partnership is formed, that the partners will jointly make an application, or the previous persons who are in control of the company, who are bringing in a new partner, will make an application, and Bharat Petroleum will in turn, my lord, reconstitute the license and allow those persons, my lord. That is what is given in the guideline. I will come to the guideline later, my lord. That was the pretext, and they say that I do not recognize you, so I am out. There was, against that order, a second round of writ petition happened, against which an order was passed where the trial court held that there is no infirmity with regard to the decision of the BPCL. So we are in appeal. Now, digressing here for a moment, my lord, two things happened in the meantime. A criminal complaint was filed by the private respondent, saying that the document on the strength of which we are claiming to be partners is a forged document. A criminal case initiated under section 200 CRPC, because in forgery, my lord, below 7 years, so my lord, it will be a complaint before the magistrate, my lord, happened, my lord. That case, its current status is that the police has filed its charge sheet and says it's an FRT. So the document, the veracity of the document, so far it relates to the inquiry whether the document is forged or not. Police says it's not a forged document, it's an original document. An application under 173(8), that's a Narazi petition, where the way we call it here, my lord, has been filed before the magistrate court. That is pending. And, my lord, when they disputed this whole issue, we filed a title suit mistakenly before Kalna court, my lord, which we thereafter realized, because it's under 21C15 of the Commercial Courts Act, it should be a commercial dispute because it's a dispute between the partners. So we have transferred the suit before the Asansol. This is a separate, because these facts needs to, because although these are not a part of, my lord, the writ petition, but it is my duty, my lord, to, my lord, say what is the other proceedings pending. Now, my lord, so far as the point of law involved in this matter, my lord, there were 2 points, my lord. Perhaps an affidavits were filed. This matter was heard finally, and an order was passed on 27th of March, my lord. So today, where we stand, my lord, so far as a possible point which the respondent can take, on which also the BPCL has taken, the point is that you had the trial court has taken that you have an alternative remedy. So you avail that alternative remedy. Alternative remedy is before the authority. So you did not avail that remedy. That was one point that was argued, my lord. So answer to that point, my lord, although that is not my main point, but I would like to answer this point, is when the first round of writ petition happened, my lord, the court sent us back to the authority to avail that opportunity before the authority, so that the guidelines with regard to how a license is to be, my lord, offered or granted, my lord, that has to be settled. And we exhausted that remedy and thereafter came before the court after the final order is passed before the alternative forum, my lord. So that part I'm not arguing anymore, my lord. But that is where it stands today, my lord. I'm sorry. That remedy we have exhausted. Now today, the limited point of approbate and reprobate, my lord, and acquiescence, my lord. 2015, the
No. Sorry for interruption.
I'm grateful, my lord.
Ultimately, it's a license.
Yes,
There is no vested right.
absolutely
If
not.
there is a violation or infraction of the condition, the licensor is entitled to cancel the license.
Absolutely, absolutely.
This Ambika service station was originally interested, a licensee was a partnership firm
Yes,
consisting of the appellant and his mother.
yes, yes.
So maybe from 2015 to 2022, you have inducted somebody inside the partnership.
No. We were inducted. I'm sorry, my lord.
Who were the original licensees?
Original lessees were the private respondents. my
All
lord.
right. So you got into the,
Yes,
but the problem is you will not be recognized by BPCL unless and until prior approval is obtained.
absolutely, my lord.
That
I
is the guideline.
join issue with
And therefore, there are two remedies available. One is you can go before the authority stating that it is true, sir, I became a partner. Probably they did not obtain prior approval. Fact remains in 15 to 2022, I was also part of the business. Now things have fallen apart, etc. So you initiate arbitration proceedings in terms of the guidelines.
there is no arbitration clause in the policy guide.
Or you need to file a suit. That's your only remedy. Because what they did was illegal. They will lose the license. You will not get anything. So your claim for damage, you cannot specifically enforce the license. It is under a guideline. And nobody is, and you said it is a company owned, company operated outlet with them as the licensor.
Yes,
It's a COCO, COCO. Correct?
it is a COCO.
It's
Yes,
a COCO
yes, that's correct.
outlet.
That's correct.
And therefore, it is at their will, BPCL's
Absolutely,
will.
absolutely. I
to
join
either
issues.
have them or not.
I join
If they
issues.
say 6 months, you're out. We want to run with our own staff. They can do. They can. This is all an interim arrangement. So, based on a license in a writ court, it's very difficult.
I understand.
And now this man has got to say that this document is forged, and you are now successful according to you. You succeeded in establishing that it's not a forged document. So your remedy lies with the private respondent, and thereafter you sort it out, or you get a decree or something like that. And even assuming you get a decree that the partnership was rightly constituted, I've infused so much of funds. Still, BPCL can refuse.
Absolutely,
refuse to
absolutely.
recognize
I
and
absolutely agree
terminate
on
its
this point.
license for violation.
I absolutely agree on this point. May I take a small instruction?
Yes. Because of this dispute,
yes, my lord,
both of you are going to lose.
Absolutely, my lord. May I suggest this,
Best
my lord?
thing for BPCL is to cancel that man's license. And you put your own people and run the outlet.
On behalf of BPCL, may I submit that?
No, cancel the license.
Yes.
And what
Absolutely,
right
it has come to the knowledge they have violated the provisions of the dealership
Or you
license.
can do one thing, sir. We will send them to you. You they have a discussion. Suppose there is a, see.
I'm agreeable to that.
Actually, by initiating this dispute with the private party, you are going to be the loser, and he is also going to be the loser.
Absolutely.
Unless he survives,
Absolutely.
you don't survive.
Absolutely, my lord. I absolutely agree.
And for both of you, he is your common enemy.
I am holding my right now, my lord, the amount of funds I have infused, and with regard to
yes. Very difficult to get inside.
96% of shares are being controlled by us.
No, they'll be very arbitrary. No, they'll be very arbitrary. You see the license condition, it will be thoroughly one-sided. No bargaining power. Sign in the dotted line.
It is.
And if it is a site where you own the site, for 90 years you can't evict them. Most arbitrary agreement you can ever see in independent India. Government is agreeing with it.
May I suggest something, my lord?
Only one thing, my lord. No, they are saying
The
they have
best is you sit, sort it out.
Yes, my lord.
That was the
And
intention.
jointly approach it.
That was the intention of the learned judge below. But the fact is this, they said that, the learned judge said that in terms of the reconstitution policy guidelines, my lord, they may file an application before the authority, and there is a provision that we can reconstitute. The firm can be reconstituted and the new
Until
directive
then,
can
let
form.
until then, let the outlet run.
Yes, my lord.
It is because in public
If
interest.
they don't run, then I will be financially loser.
Outlet now
I
is,
will again have to
because
get
of this dispute, the outlet now is closed, my lord. Now it is not.
No, that will run. And whatever arrangement was there, who was the check signing authority as per the reconstituted?
Us.
And what was the profit sharing between both?
96% for us, 4% for them.
The partnership deed which they are seeking, that is under challenge. They themselves have asked for specific performance of that deed.
You lose the license, sir. If your client maintains this.
They were workers, my lord. That's what they have done.
Unfortunately,
they have a document and they produced it.
May I?
Lot of businesses are run by the workers. The owners are sitting at home, probably checking their account status.
Is this the agreement or the dealership was entered into between BPCL and the private respondent?
Yes.
And the read petitioner or the appellant herein is absolutely a stranger, my lord.
You don't recognize him.
He may have.
No, if you don't recognize him, the consequence will be to cancel his license.
Yes, my lord. So we intended that let them file a letter or the application for reconstitution of the dealership firm. In the event it succeeds or that is in tune with the guidelines, then
for that they have to be added. If they are fighting tooth and nail.
The petitioners, the appellant here, my lord, they are no one, my lord. They themselves say that I am a partner of this firm.
True, sir, but then you lose your license.
I don't have any connection with them at all.
Maybe.
No connection.
But then from 15 to 22, some fellow has got no connection.
From 15, my lord, from 15, on the strength of that document, my lord, on the strength of the agreement, my lord, requisitions were sent to the bank, my lord, and they themselves, my lord, after sending requisitions to the bank, my lord, checks were changed. The signatories were changed.
Between 15 to 22, he has been placing indents. He has been drawing the demand drafts from some account accepted by BPCL. That he is pleading acquiescence on your part, not with them.
On behalf of the owners, on behalf of the partners.
No, you are not owner. You are a licensee.
No, my lord. On behalf of the partnership firm, they are doing it. Not as on behalf of the partners, they are doing it.
He is also a partner. He is a minority partner, but he's still a partner.
We will dismiss his appeal. We will direct the license to be suspended, and BPCL will run it with their own men. You sort out the matter before civil court, criminal court, Supreme Court, wherever, Asansol, Alipur, commercial court. Then you come after 15 years.
No, that is what the intention of the petitioner of the appellant is, my lord.
You will lose. You will lose.
That is what they have challenged. That is what they have produced a document, a forged and fabricated document, and saying that this I am the.
Will not interfere with the order, saying that this issue cannot be adjudicated because it's essentially a private dispute between the appellant and the private respondent. And the private respondent is only a licensee of BPCL. It is up to BPCL to consider what to do.
Lordship.
May I suggest one thing, my lord? Let us go afresh before BPCL, my lord.
He should be willing, no?
Yes,
unless and until you set right jointly dispute, he will not recognize you. That's where
that has to be sorted out. I understand
that. Arbitrate between both of them. Let them come to that. And he says your clients are his employees and they are the principal licensees. And how we don't know 4%, 96%. This
it cannot.
My goodness,
it's an arbitrary. Not.
This
will kindly
we'll make some observations. This intra-court appeal by the writ petitioner is directed against order dated 27/3/2023 in WPA 471 of 2023. The dispute is between the appellant and the private respondents concerning a partnership agreement which is stated to have been entered into for the purpose of managing a petroleum outlet under the name and style Ambika Service Station, which is an outlet established and owned by BPCL. The appellant's case is that the partnership was reconstituted, and in terms of the reconstituted partnership, 96% share will inure in favor of the appellant and 4% in favor of the private respondents. And this position continued from 2015 till 2022. It is at that juncture, a check issued by the appellant was not accepted by the BPCL on the ground that they refused to recognize the appellant as a licensee. It is an admitted fact. It cannot be disputed that the reconstitution of the firm / licensee was without prior approval of BPCL. If such is the factual position, it is in clear violation of the guidelines notified by BPCL. Therefore, it would be well within the jurisdiction of BPCL to cancel the license itself granted to the private respondent. However, we do not wish to travel thus far, as we are clear in our mind that the dispute is essentially a private dispute between the appellant and the private respondents. Therefore, in the best interest of these parties, it is up to them to resolve the dispute and then approach BPCL for the purpose of reconstituting the partnership and if consensus is arrived at between the appellant and the private respondent, that would be beneficial to both parties, as it would be a step to save the license which has been granted in favor of the private respondent by BPCL. On the other hand, if the parties are not ad idem and they continue to fight their case before various forums, then the ultimate result would be BPCL would cancel the license granted in favor of the private respondents. Therefore, we are of the view that earnest attempt can be made by the appellant and the private respondents to resolve their private dispute and then approach BPCL with a request for reconstitution. Till then, considering the public interest involved, BPCL should make the outlet operational, and for which purpose of operation which has now been suspended. We direct BPCL to open the outlet and operate the outlet by deploying their own staff till the dispute is resolved between the appellant and the private respondents. The above observations, the appeal stands disposed of.
Because my submission, that the whole document which they are relying upon, that is disputed, and 2022, only they had asked for that the transfer, that application of the renewal of the partnership deed.
That won't.
They waited for 7 years. 2015, supposing they have come into the partnership, 22, they had applied for change of the.
Yeah, until then, probably BPCL was not aware.
No, not that.
BPCL was aware.
Is very clear.
Because the secretaries were changed.
You sit across.
I have to sit with an outsider to settle, to save my license now.
With the above
That is the
observations.
confusion now.
Next.
Lordship, may I make one humble submission, my lord? Lordship, we are ready to sit with them.
But he is refusing to recognize you.
I understand.
My lord, we are ready, my lord, but let him send a mediation, my lord.
Lordship will kindly. I agree.
You can.
Lordship will kindly appoint somebody, my lord. We'll go for mediation, my lord, and then we'll
kindly appoint.
You yourself can mediate.
My lord, kindly appoint.
In this writ petition, that will
brothers,
not. We leave it open to the parties to mediate and settle the matter. We grant liberty to the appellant and the private respondents to settle the matter among themselves. In our opinion, if the parties agree upon 1 or 2 mediators to resolve the issue, we are confident that the matter can be resolved. Next.
Mr. Shako Shen, my lord.
You decide.
My lord, yes, my lord, you can consent, my lord. My lord, if my lord kindly appoints, my lord. Kindly appoints, lordship, my lord. Otherwise, my lord, later on outside court, my lord, the parties again is going to be, my lord.
It is suggested by the learned advocates for the appellant and the private respondents that Mr. So-and-so may be nominated as a mediator. The parties are directed to approach the learned mediator to
Yes.
My lord,
Mr.
Appreciate.
Feroz Edulji, my lord, he is present in court, my lord, and Mr. Shako Shen, my lord.
You give the names
we'll give the names, my lord.
with their disposed of. Next.
Item number 11.
Item
11,
number
Your Lordship,
11,
I
my lord,
appeal
I'm
for
just
the
praying for a
appellant.
day's accommodation on behalf of the Enforcement Directorate.
Lordship, I have mentioned the matter. Your Lordship kindly hears me out, Your Lordship.
Lord, I'm
It
just praying
was
for
their
1 day's time.
adjournment on the ground of adjournment. In this matter, Your Lordship, the writ petition was preferred, Your Lordship, and they have sought for an adjournment, and in the interregnum, they had
Is the appeal. We have not acceded to his request.
Lordship, Lordship,
You are aggrieved by the provisional attachment under PMLA.
Lordship,
Contended the council on the expiry of 180-day period, it comes to an end, correct?
Lordship,
As per section 5, it comes to an
Lordship,
end.
Lordship. That is my matter.
Then what happened to the writ petition?
Lordship, Lordship, I had preferred,
Oh, yeah, appeal is there.
Lordship,
Because an appeal is maintainable, the writ was dismissed.
Lordship, without even going into the issues whether that 180 days delay and they have passed a final adjudication order beyond the period of 180
It
days.
is once again a disputed question of fact.
Lordship, there is no disputed question of facts, Your Lordship.
But
It is
see,
a point of law.
No, these are all special enactments. And very seldom the writ court should allow you to bypass. Unless and until you say, suppose you have to go before a subdivisional officer or a tahsildar. Then you can say there's an appellate tribunal.
Lordship, appellate
Authority.
Lordship, the appellate authority is one to which I can prefer my final adjudication order, not the provisional attachment order. Lordship, may kindly.
No, you show the relevant provision.
Lordship, may I only in a nutshell place the facts first?
First, you show this relevant provision.
Section 5.
Section 5.
5.
We don't have the act, PMLA Act. Is the appeal function. Save as otherwise provided in subsection 3, the director or any person aggrieved by an order passed by the adjudicating authority under this act may prefer an appeal to the appellate tribunal.
Lordship is reading
26.
Lordship, I am at section 5.
Oh, sorry. This is
Section 5, Your Lordship.
sorry.
That is where is the initiation.
Yes.
Lordship. Section 5 provides for attachment of property involved in money laundering, where the director or any other officer not below the rank of deputy director authorized by the director for the purposes of this section has reasons to believe the reason for such belief to be recorded in writing on the basis of material in his possession that any person is in possession of any proceeds of crime and such proceeds of crime are likely to be concealed, transferred or dealt with in any manner which may result in frustrating any proceeding relating to confiscation of such proceeds of crime under this chapter. Now, this is relevant. He may, by order in writing, provisionally attach such property for a period not exceeding 180 days from the date of the order in such manner as may be prescribed. Lordship, I am only aggrieved by this. The statute of section 5 has to be read first. It is the provisional attachment order which is subsequently confirmed in section 8, and section 8 order has to be challenged before the appellate tribunal, not an order under section 5.
No, the learned judge says challenging the order of adjudication, confirmation of provisional attachment order.
Lordship, that is section 8. Now section 5. The confirmation of section 5.
You, according to the writ court, you challenged the order under section 8.
Only under section 5, because when I was before the writ court, the order under section 8 was not passed. My prayer in the writ petition was
to defreeze the account since the provisional attachment order which was passed on 29th October 2021. Lordship may kindly take note of the dates, Your Lordship. 29th October 2021 was the date of the provisional attachment order. Accordingly, within a period of 180 days, the final adjudication order under Section 8 has to be passed. If they fail to pass it within a period of 180 days, then the provisional attachment goes. That is what the statute is reading. Now, in Section 5, when such order goes, if the Section 5 order, which has lost its effect on 19th of April 2022, that order was confirmed on 25th July 2022 after my preferring the writ petition and after they had sought for time. It was not me who had sought for an adjournment before the Honorable Court. The adjudicating authority fails to pass the final adjudication order within 180 days. Now, when this order, which has already lost its effect after the expiry of 180 days, I am putting only this one question to myself, whether an order which has lost in effect in Section 5, can that be confirmed in 8? And if that cannot be confirmed in 8, can I prefer an appeal from that order under Section 8?
That's a good ground to say that the 8 order is illegal.
Lordship.
That's a good ground under 25 to go before the tribunal to say that the authority had no jurisdiction to confirm it, because on the date when he took up the matter for confirmation under 8, by then 180 days had lapsed.
Lordship.
Probably it become functus officio thereafter. So it's a good ground to, you don't bypass that appellate remedy.
Lordship, I cannot bypass the appellate authority. Lordship, my
It
writ
is true-
petition,
No, it is true during, you challenge the provisional attachment order.
I have only
You have already
challenged
filed
not
the
the
appeal.
provisional. I have only challenged that beyond the period of 180 days, my accounts cannot be kept freezed.
Correct.
That was only my contention.
Correct. But what is, it is basically on the time limit. But there, during the pendency of writ petition or whenever it is, in a Section 8 order has already been passed.
Lordship, that is where my grievance is.
According to you, it is
Section 8
illegal. Illegal.
Section 8, how it could have been passed when
At
the
the
Section
tribunal you will
5,
have to do.
Section 5 had already lost its effect.
At the
Lordship, to that, Your Lordship, there is one judgment of the Honorable Division Bench of this court, Your Lordship, which has considered that such provisional attachment order, which is beyond the period of 180 days, that was set aside. One by the learned single judge, and thereafter such order was confirmed. That orders are at page 243, and the Division Bench order is at page 257. Lordship kindly takes up these two orders. Page 243. Lordship, may I point out the relevant portions?
Yes, yes.
Lordship. Page 243 is the order passed by the Honorable Single Judge, Your Lordship. It is with regard to the issue of 180 days. Lordship, the ordering portion at page 256.
In that case, they said because of this order of the Supreme Court,
Lordship.
that COVID.
Lordship, they have tried to take recourse of the order of the Honorable Supreme Court passed in the suo motu writ petitions.
But your period is not covered in that COVID period. Is it covered?
Lordship, that is the difficulty. My period could have been covered, could not have been covered. But the difficulty is that even while passing the final adjudication order after 180 days, the adjudicating authority takes the plea that since we are protected by the orders of the Honorable Supreme Court, we can merrily pass it beyond 180 days. That has been ruled out. Once by the Honorable Single Judge and thereafter by the Honorable Division Bench, which the order is at page 257.
But where is the section 8 order?
Section 8 order, Your Lordship, Section 8 order. Parkon. Lordship, this is the Section 8 order, Your Lordship, 25th July 2022.
In that, in the preamble, does he state about this 180-day period?
Lordship, they have stated at the last page, Your Lordship, they have taken recourse to that 180 days relief at the very last.
Although the statutory limitation period for passing an order under 83 has expired. No, that is for him. With regard to your contention, that Section 5 order itself has worked itself out.
Lordship, that was not considered by them in the final adjudication order. This was passed in a haste.
No, you were heard in the matter.
Lordship, I was heard, Your Lordship. My reply was to be heard, Your Lordship. I filed my reply and there was a rejoinder. That has to be heard. That was never heard.
So that is a good ground to challenge this order before the tribunal.
Lordship, may I only humbly, Lordship,
You have already challenged.
I've already challenged it before the appellate authority. Lordship, that is Section 8. The Section 8 order I have challenged.
See, therefore, the order passed under Section 5 stood merged with order passed under 8. One of the grounds of challenge is, the principal ground is, on the date when 8 order was passed, the authority had no power. 180 days is over. That is main point. Second is, of course, you are saying that you are not heard in the matter, reply was not considered, etc. So this factual matter will be gone into by the appellate tribunal.
Lordship, I bow down to that. Your Lordship, on the facts, I'll not make any submission. On the factual aspect, whether I was heard or not heard, Your Lordship.
Single bench order and the division bench, they came before this court challenging the provisional attachment order under 5-1.
I have also come up in the writ court challenging the order under Section 5-1.
But then already an order under 8 has been passed. Appellant has already filed an appeal before the tribunal. Now, why do we have to entertain a writ petition at this stage?
Lordship, the only contention is that, Your Lordship, this order which has been passed, since it is passed after 180 days, that could not have been considered at any point of time.
No,
Lordship, I may be allowed to place all the facts before the appellate authority.
Yes.
Lordship, only
He will decide, we will direct the tribunal to decide the issue as regards the jurisdiction of the adjudicating authority to pass the order under 8, considering your contention that he becomes functus or the order automatically stands lapsed. That will be decided as the first among several issues.
I bow down to that. Lordship, if I may only make one submission, since Section 5 order had already lost its effect on 19th April 2021, Lordship, my accounts may be defreezed.
That
is the...
No, that the tribunal has got power for interim relief. It has got power to interim relief. They can direct them to be, the attachment to be lifted. Suppose there are 5 accounts and you are a running industry or something, payments have to be made to the workman, etc. They will definitely do.
Lordship, the difficulty is that, Your Lordship,
who amassed 7.5 crores that has been seized. There's no question of
that cannot be, that is only on facts, Your Lordship.
Thank you, madam.
Lordship, before this honorable court, Your Lordship.
This intra-court appeal by the writ petitioner is against the order dated 27th March 2023 in WPA 1161 of 2022. In the said writ petition, the appellant had challenged the order passed under Section 5 within bracket 1 of the Prevention of Money Laundering Act 2002 within bracket PMLA Act, dated 29th October 2021, by which a provisional attachment has been made of the appellant's accounts, bank accounts. The contention of the appellant was that the order, the provisional attachment order passed under Section 5 within bracket 1 of the Act loses its efficacy on expiry of 180 days period. It is not in dispute that during the pendency of the writ petition, an order under Section 8 of the Act was passed on 25th July 2022 making the provisional attachment order absolute. And as against the said order, the appellant has filed an appeal before the appellate tribunal under section 25 of the Act. The question would be as to whether in the facts and circumstances, the writ petition can be entertained or not. The learned advocate would place reliance on the decision of this court, the decision of the learned single bench of this court in the case of page number
43 starts.
Decision of this court dated 27th June 2022 in WPA number 9699 of 2022, Hiran Panchal and another versus Union of India, and submits that in the said order, the learned writ court had quashed the order of provisional attachment on the ground that it is lost its efficacy due to lapse of time, that is 180 days. It is submitted that the Director of Enforcement preferred an appeal against the said order in MAT number 122 of 2022, and the Honorable Division Bench by judgment dated 12th December 2022 dismissed the appeal filed by the Director of Enforcement and affirmed the order passed by learned single bench. In our considered view, the grounds which have been canvassed in the writ petition and accepted by the learned writ court could very well be canvassed by the appellant before the appellate tribunal. The subtle but marked distinction in the case on hand is that an order under section 8 has been passed on 25th July 2022, and the appellant has already filed an appeal against challenging the said order before the appellate tribunal. Therefore, it is but appropriate for the appellant to canvass all grounds before the appellate tribunal, including the ground that the adjudicating authority could not have passed the order under section 8 of the Act beyond the period of 180 days, as the order of provisional attachment made under section 5 within bracket 1 loses its efficacy on expiry of 180 days. One more reason which weighs in our mind to refuse to interfere at this stage of the proceedings is that the computation of the period of 180 days is not purely a question of law. It is a mixed question of fact and law, and therefore the department is required to be heard in the matter. Furthermore, the adjudicating authority has passed an order under section 8 of the Act dated 25th July 2022 after hearing the parties. And on this also, the appellant has a grievance that the reply submissions of the appellant was not considered by the adjudicating authority, and the order under section 8 has been passed with utmost haste. Therefore, all these grounds which are now being canvassed before this court are to be raised before the appellate tribunal, which will be adjudicated by the tribunal in accordance with the law. With the above observation, the appeal stands.
Lordship, may I only pray for this, Your Lordship? Let this point be decided first without before deciding the appeal, Your Lordship.
The appellant can pray before the learned appellate tribunal to decide the limitation issue as first among the several issues which the tribunal may take up for consideration. If such prayer is made, the appellate tribunal shall consider the same. Next.
Grateful to Your Lordship.
Item number 12.
আমার ওই অর্ডারটা দিন, আমার ওই মোটা অর্ডারটা।
Item 12.
For respond number 1 bank.
Lordship, may I get back the order?
That order.
আমার একটাই copy আছে। Affidavit of service.
My lord, in item 12, Advocate Arijit Vardhan is appearing for the appellant, my lord. There has been a bereavement in the family. I kindly pray for not today.
Position had already been taken on 22nd of April.
21st. On 21st, position was taken, and upon taking position from the
Superintendent of Police, concerned Superintendent of Police Bank has handed over the position to the highest bidder. Lordship, may I hand over the relevant inventory and punch number?
He says there is a bereavement in the
Lordship,
family. It is submitted that who's appearing?
My lord, Advocate Arijit Badhan.
It is submitted that Mr. So-and-so is appearing for the appellant and there is a bereavement in the family and adjournment is sought for. The learned advocates for the respondent state and the bank submitted that already possession of the property in question has been taken over on
21st of this month, Lordship.
21st of April 2023 and it has been handed over to the highest bidder.
Lordship. On the same day.
On the same day. Let this matter appear on Monday.
Yes, grateful, my lord.
No, when? Wednesday.
Grateful, my lord.
You tell me.
Lordship, Wednesday, I have some difficulty. Can it be preponed to Tuesday or Thursday?
Thursday.
I'm grateful, Lordship.
Thursday, same position.
Grateful, my lord.
Not taking Wednesday and Thursday for the appeals.
You don't know what we are taking. All.
I'm grateful.
Item number 13.
13, I am for the petition. I'm for the appellant.
My lord, I appear on behalf of the state. Last occasion, there is the direction for filing a report, my lord. The report is ready, my lord. Here is the report. May I hand up the report?
What is the report?
My lord, the case is, my lord, that on the 24th of June 2019, petitioner's 25 years old child was abducted. Abducted. After frantic search, when he could not be traced out, on the 26th, petitioner went and lodged a missing diary. On the 14th of July, 15 days later, the Beldanga police station, probably having some clue, called the petitioner. Petitioner went and lodged an FIR. Because thereafter he gets a ransom message that you pay this money. He shows the message to the Beldanga police station. Beldanga police station takes care of that message. On the 27th of July, 10 days later, the Beldanga police station informs the petitioner that till the 15th of July, that is one day after lodging up to the FIR, 20 days from the date of his abduction, his mobile could be traced at Beldanga. After that, for the next 10 days, it was traced at Park Street, Kolkata. They immediately directed the petitioner to go to the DD Lal Bazar cybercrime cell. The petitioner came and informed the Detective Department, Kolkata Police at Lal Bazar. They immediately took up a search, and few days later, they recovered the petitioner's mobile from a place at Navadip, which is in the Hooghly, Nadia district of West Bengal. And after recovering the mobile, they directly handed it over to the Beldanga police station for further investigation. And petitioner was asked to go and pursue the investigation there. But we came up thereafter, when after a few days also no serious progress. In 2019 only, the petitioner comes up before this honorable court and before the single judge praying for a CID investigation. The Beldanga police station comes and prays for a last chance that we are doing investigation, kindly allow us. The prayer was allowed. 1 year later, when there was again no progress, not at all any constructive progress, my lord, the petitioner comes back to this court again, praying for a CID investigation. Again, the same prayer of the Beldanga police station by dint of a report that we are doing some investigation, allow us some more time. Time was allowed, the petition was turned down. Thereafter, it is reported on the 20th of February 2020, it is a verbal report to the petitioner that the from the Superintendent of Police Parashat, a report was sent to the CID for taking up the investigation. We came and contacted the CID. The CID said that we are seeing what we can do. Thereafter, we came to know that CID sent back a report to the Superintendent of Police Parashat that we have taken it up as associate investigation. That is, let Beldanga continue with the investigation. If they need our help, we will do. This is the position. We filed a writ petition. Again, they prayed for some time that CID has taken its associate investigation. We are doing it. Allow us some time. That writ petition was again turned down, and Beldanga police was allowed to continue with the investigation. What happened after that? Few days later, at this stage, when CID has taken associate investigation, Beldanga has paid for some time, they file a final report before the court below, before the ACJM Barampur, then says that we cannot do anything, we cannot find, we are tendering a final report. Immediately, the petitioner rushes to the court of the learned CJM Barampur and files a Naraji petition, protest petition, and prays for further investigation. Further investigation was allowed. This appeal came up for hearing after that. On the last occasion, My lord, a report was called for.
Now, further investigation by which authority, which
By the same authority, because the learned magistrate has no other power to grant investigation to any other agency.
No. Was there a direction to form a special team?
No, nothing. A further investigation is allowed. I have that order with me.
But the appellant's son is as of now 29 years. That fellow is hiding somewhere.
Yes, 29 years. My lord.
He is not gone missing. He is hiding somewhere.
But my lord, for 3 years, he was the last, as it came to
whether he is,
when his food was given, my lord, he says that I'm coming for 2 minutes. My friend is calling me. He goes out with his bike. He doesn't come back anymore. My lord,
on the date, when he
25 years,
he was 25.
25.
As on date, he will be 29.
29.
And you say that 25-year-old boy, he took his Pulsar motorbike, etc., and he left. He's hiding somewhere, or he's
my
not
lord,
in the
there was
country?
a call. There was a message received from by the petitioner stating that you pay this money, we will give you, your son will come back. He shows the message to the Beldanga police station. My lord, at this stage, my lord, it is understood that Beldanga police station can make
He has crossed the border.
My lord,
Or he is,
a chance by the CID, but if they can make out if the son is at all alive or not.
what is your submission? Yes, sir.
Chance by the CID, if they can make out is at all alive or not.
We filed the exhaustive report as far as the entire investigation.
Reports are not going to help.
No.
Whether this fellow can be traced or not.
No, he's not being traced.
And protest petition was filed, further investigation order.
Directed thereafter, but end of the day, not today an adult person, if he does not want to return home, can anybody find? Anybody in this entire country? But the
one second. After coming here, Chief Justice allotted us the habeas corpus petitions. We were dealing with that for say around five months. I was also dealing with the same petitions when I was in my parent high court. There, the maximum period within which they will trace, the police will trace is 10 days. However difficult it is, within 10 days.
That is where the first writ petition was filed within a few months.
But here, we have got very porous borders. And we have had cases where for 6 years, they are not able to trace. The minor girls who are in the northern part of the state. Because the borders are very porous. At least in 5 states, we need to make the investigation. And 80 or 90%, they cross the Indian territory, which is very easy. North Chowbis, easily it can be crossed. It will take 45 minutes for you to cross the border. It's very porous. You go to Purulia, the same problem.
My lord, everything is possible. I bow down. But one thing, my lord.
Now, if the court has already ordered for further investigation.
My lord, that's a magistrate with the same agency.
What you can do is, one last attempt, you form a special team. And you do something.
My lord, unless until CID is directed, my lord, this special team will never.
He doesn't want to come back, sir. He doesn't want to come back.
My lord, may I submit one thing?
Otherwise,
when investigation started, my lord, initially after 4 months, the petitioner told me that the police is saying that your son is involved in an NDPS case. The petitioner said, very well, where is the FIR, and you arrest him. Then petitioner comes back after this order of the online Chief Justice was passed last time. That the building opposition threatened the petitioner that if we find any call from your son to you, if we had any call, we would have gone to the court, running after the shuttling from one court to the other court. These are things going on, my lord. If my lord, I may submit one special team, my lord, may be formed under the guidance of the CID, my lord. And I can also pray with your lordship one thing, that the time may be fixed. It is not that the investigation will go on and on. Because CID has other important investigation also. A time fixed for 6 months, and if they cannot trace him, the investigation will stop. My lord, it cannot be kept anymore here where it is. Now, 3.5 years have passed.
What is the stage of further investigation?
Look, further investigation is on, because in a case like this of a missing person, there will rarely be a closure report unless the person is found. Because your lordship has said this, but in my few years of this doing this sort of work, we have recovered a girl after 26 years. There was a child who went missing. She was subsequent that girl. I was amazed because for a child of 26 and that she was Must have been 7 or 8 years old when she went missing. So the entire physical appearance changed. But she was able to, this girl was able to recollect from her memory, was caught in some railway station. She was begging over there, and then she asked one policeman over there, and then they found out details of this.
No, his endeavor is that if suppose he is involved in some heinous crime, etc.
No, that I'm not going into these issues. Today we are before Lordship. Today, if he was involved in a heinous crime, the police would have got information through their network. So that is not the case. Then I could have immediately said that he's there in arrested in jail, whatever. That. But today, my lord, if a person, my lord, as far as my lord, a writ petition, a person aggrieved comes to this court, if I have done, there is inaction on my part.
No, there's no inaction. What he says is the investigation or search is being prolonged unreasonably.
A chance may be given to some other agency that if they can try and find him out.
But today,
my lord, it is not that they are under 3 and 5 years when he cannot be.
By this intra-court appeal, the appellant being dissatisfied with the order passed in WPA 1863 of 2020, dated 2nd February 2021, has filed this appeal. The complaint of the appellant is regarding his son who went missing. On the date when the petitioner's son went missing, he was aged about 25 years. And as of now, his age should be about 29 years. And the allegation is that the appellant's son was abducted on 24th June 2019. Admittedly, the appellant had been pursuing the matter before the concerned Court of Chief Judicial Magistrate, and in a protest petition filed by the appellant, the concerned court has already ordered further investigation. The appellant's grievance is that the investigation is being prolonged endlessly, and therefore a specialized agency should be directed to take over the investigation and complete the same expeditiously and trace the whereabouts of his missing son. In our view, considering the age of the missing son at present, and also taking note of the fact that the court of competent jurisdiction has already directed further investigation in the matter, we direct the concerned police to form a special team and pursue the investigation diligently and conclude the same within a period of 2 months from date and file a report before the concerned court. In the event the appellant is not satisfied with the report that may be filed by the police before the concerned court, we grant liberty to the appellant to avail other remedies open to him under law. With the above observation, appeal disposed of. Next.
My lord, one Hon'ble submission may I make, my lord. The specialized team that my lord has directed may be headed by an IPS officer. And a deputy superintendent of, at least a deputy superintendent of police, my lord.
Already lot of problems, sir.
my lord.
Next. Sorry, sir. Thank
Item number 14 to 17. Sir, I appear for the appellant.
I'm grateful, man.
Well, this is a very classic case of, I can use these words, a fight between science and law. I stand for the science. My other side, they stand for the law. Lordship need not see the documents for the time being.
Okay.
Well, the appellant is the West Bengal Electricity Regulatory Commission. Well, there is an act called the Electricity Act 2003. Under the act, there are 2 commissions. One commission is the Central Commissions, which is for the entire country. Only one commission. And for the rest, the respective states, there is a regulator. I am representing that regulator for the state of West Bengal. The bone of contention is, well, we are aware because of the science that sunlight, this is a renewable source of energy. Water is a renewable source of energy. Wind is a renewable source of energy. The bone of contention is, I have the statutory power under the act to frame entire set of regulations. These are all delegated legislations, and there are interpretations up to the 5-judge bench of the Honorable Supreme Court that under the Electricity Act, state should distance itself so far as the tariff and other electricity aspects are concerned. Now, I have framed based on my own delegated legislative power, saying that what should be the renewable source of energy. Well, I have said sun, I have said wind, I said biomass. And in our country, Malad, we have a ministry. It is called MNRE, Ministry of New and Renewable Energy. Malad, MNRE, they have their scientists, they decide whether there is a new futuristic energy, they can source it. So for that ministry. My statutory regulations, I have said A, B, C, D are the renewable energy and whatever may be approved by the MNRE. That is my definition, statutory definitions. My statutory definition is in sync with the statutory definitions of the CERC and the rest of the country. I have given the definitions of all others. I have received a direction from the state. Declare industrial waste as a renewable source of energy. The point is, day by day, we are, my lord, slowly, gradually shifting towards the greener energy, and that's a renewable source of energy. To do that, there is a compulsion for every distribution licensee who supply electricity to the consumers, that while you would be procuring your 100% electricity from thermal, that is fossil fuel, by burning coal, etc., every year certain percentage mandatorily you have to source from renewable source of energy. Like you have to take, for an example, 3% from the solar, maybe 1% from the wind, etc., etc. Today, if this tweak, the I wouldn't say legislate because that's the directions of the state. Today, if I accept the directions of the state, that means if I change my statutory regulation and I say that industrial waste will also be considered as a renewable source of energy, there would be, apart from all other the illegalities, there would be two major, my lord, illegalities on the point of science, that what is the renewable energy, my lord? This is hardly a matter of stretching interpretation. It has to be. I don't mind that MNRE, the scientists, they say it is so. So, my lord, my entire effort before the honorable single judge was that this is a matter of science. There is a ministry. Please include the MNRE as one of the party respondents so that you get to be informed with this scientific, whether the industrial waste can at all be a renewable source of energy or not. My submission was recorded, but the learned single judge made a different view, and ultimately set aside my entire statutory regulations, declared that industrial waste to be a renewable source of energy. This was challenged by me. Incidentally, it was moved on the first day before your lordships, because that day the Honorable Chief Justice was not there. And
what did we do?
Lordship stayed because it was the larger issue was involved. So Lordship stayed at, and that stay because of the reason the Honorable single judge also, after delivery of the judgment on my prayer, Lordship may remember that that there was for 2 days Lordship had the determinations, and because of the urgency I mentioned.
That is the 27th April order.
Yes. That was on 27th April.
Now the appeal has to be heard out finally.
Before that, there is a small aspect. This matter was actually heard out. My submission was also completed, and they also, I would say, their majority submissions are over. But the Honorable Chief Justice, the other bench, because of the positive, it was very normal. But I was able to convince the other honorable division bench of requirement of presence of the MNRE for getting a scientific stand. There was the directions by this honorable court on 18th of August, by which the MNRE was directed to be made as one of the parties and to file a report. And on 18th of August 20.
Let the needful be
Yes.
for implement of the Ministry of
Yes.
New and Renewable
But
Energy.
that happened after a prolonged hearing, and I said that. So honorable division bench was convinced on that.
Now they are parties.
Now, not only their parties, now they have come up with an affidavit. Today, MNRE has said what I exactly said. Industrial waste is not a renewable source of energy. My lord, in fact, this matter has a larger impact, because Lordship may kindly look at one thing. Today, if I want to go for the greener with my statutory obligatory regulation saying that compulsorily you have to procure electricity from the sun, from the wind, from the biomass, etc., etc. By taking advantage of tweaking this, one will take electricity from industrial waste. Well, one thing I have not said, it is more of a fact. The writ petitioners, they burn coke. Now, it's an admitted case which they have also described very correctly, that their burning of the coke is sourced by burning coal. So that is a fossil fuel. Now, their argument is this: we are burning the coke, correct? But while burning the coke, thereafter, we are also doing two things. One, the heat which is coming from it, we are using the heat for the purpose of producing electricity. Now, the stand of the regulator was, factually you are right, that you are using your heat, which is good for the environment. That's why you are called as a co-generation, for which there are different other mechanisms to give you little more benefit. But because you are doing something good towards greenery, does not make you equal to sun, does not make you a renewable source of energy, because your source is the burning coal, fossil fuel.
That is not a green fuel.
That is not a green fuel. And it is more a matter of science. It is more a matter of science. And there are other legal points.
Sorry for interruption. What was the writ petition for?
Writ petition challenging my statutes by which I defined what is renewable source of energy.
So they wanted this to be inserted. What is the direction issued by the single?
The direction issued by the honorable single judge was, my regulation is set aside. And I have to treat industrial waste as one of the renewable source of energy. For that reason, I have to make a regulation. So today we are in a vacuum.
So actually there was a resolution by the regulator.
Yes.
Saying that this industrial waste will not be a renewable source of energy.
Yes.
Or
Well, I would not say in that negative sense. I'm saying yes. Possibly my learned friend, I have understood why they have stood. One thing which I have halfly said, not fully, I would be saying fully also. In the state of West Bengal, unlike the rest part of the country, the industrial waste in my own regulation was considered as a renewable source of energy for some period of time, which was wrong.
From 2013.
Yes. Now there was a judgment by the appellate tribunal on that. And I can use the word, there was a better sense and better independence on me also as a regulator. So I made the amendment in the definitions after seeing the definitions of the Central Electricity Regulatory Commission and all the states throughout the country, and after going to the depth of it. So yes, if I say this word, that from the day one, what was the definition? They may have a say that yes, on the day one, industrial waste I wouldn't say day one, from 2013 onwards, that was there. So it is not coming from the 0 point. So they were aggrieved by amendment of the definition by myself, which they challenged successfully. And now I am before your lordships, and there is an interim order. I am protected this.
Now the stand, now the ministry is, central government is being implemented.
Clear cut stand.
And who will appear for central government?
My lord, Ms. Sushmita Shaha last time appeared. Yes.
Your affidavit is on record?
Yes, it is on record.
You have also used for the petitioners.
You file your.
But that is all record. That is all are on record.
And we have also used supplementary affidavit against that, Lord, of that affidavit of exception. Lord, indicating the different stand.
No.
of ordinary and
They filed an affidavit. You have filed an affidavit in opposition.
Yes, yes. But they
Exception.
that's the nomenclature is diverse. They filed.
also supplementary affidavit to that exception. So I have two affidavits on board. No,
You served those affidavit.
I have received. I have.
You have served copies. What, this is supplementary affidavit and exception.
This I appear for two sets of writ petitioners. One is for Bengal Energy, the other one is for Tata Power. Now, Lord, this is with respect to Bengal Energy. And Lord, this is Tata Power. If Lord, I have served this affidavit on all the respondents and Lord, including that.
Well, a lead matter before the Honorable Single Judge was the Bengal Energy, which is item 14. So for the purpose of convenience, Lordship may take one matter as a lead matter because fundamentally it is a question of law. And whatever would follow, my lord, this will all.
Electricity matter, the ultimate Lord, comment of Lord, Department of Power is final. Now, my lord, here there is a discrepancy between the stand with MNRE and Lord, Department of Power and Government of India in the international level. That is exactly what we have tried to demonstrate with your lordship.
But what can a writ court do in this?
Yes.
You see, actually, if suppose you say the amendment suffers from some constitutional infirmity, it is inconsistent with the parent enactment, then the court will interfere. We have not heard you, we'll hear you. But can the writ court say, no, this is a fossil fuel, this is a renewable energy, please include this. It may be true.
Precise.
You are for?
My lord, all the licensees, Lordship may kindly take note, are here because this is practically for the licensees. If they are allowed to get industrial waste as a renewable source of energy, they will not be requiring to go to sun or the wind or the other, because there is a cap, like you have to procure from the greener renewable source. So there is, I can use the word catch. They are respondents, but it is basically regulator versus everyone, including the state.
So that was not an issue with the repetition really, because the entire repetition has been seen and for WTA. We are having without difficulty in our contextual obligation. So there is not something. Now there are three applications filed not to segregate solar power and the problems regarding solar power. One by the state of West Bengal, one by WTACDCL, and the other an addition of party by Garrison. Now these.
Now you are appearing for the Ministry of what is it? Ministry of Power.
My lord, the Garrison is not a party. Is not a party. She can appear for the MNRE. But garrison engineer has never been a party before the honorable single
That's a
judge.
different matter.
This bit is co-generation.
No, no, that everybody is suffering.
The problem is, we went in the
But I have strong objection to that. They took this point before the other honorable division bench. And I objected to,
No,
and
how
I
far-
said that entire matter be hard out. And actually it
No,
was
for
hard out.
how many days all of you argued?
My lord, I argued, I believe, only for one full day and one half day.
So in July, we'll hear AG also.
Yes, my lord, may I, my lord, seek one indulgence from your lordship? My lord, just have a look at just one paragraph of the judgment.
I'm
Oh, I
planning to go to Justice Saura Ghosh's
Oh,
house because the body has come from SSK and there's going to be no funeral because the body has been donated and it will be remain there for only 3 hours or so. So we will fix
My
a
lord,
date for the appeal.
Lordship may
Yes, my
kindly
lord.
fix a date in July. I don't mind it, but it has to be hard out. No applications, no, my lord, shortcut.
My lord,
Because-
what has happened? The only challenge, my lord, in effect, my lord, in the writ petitions were, my lord, the amendments which related to co-generation. But what has ended up happening, the learned judge in one paragraph, my lord, has, my lord, set aside the entire regulation. So the result is, my lord, because the test of severability has not been discussed at all. It's been settled by
You
Supreme.
are also an appeal cross.
Yes, my lord, I filed a cross objection, my lord, on that aspect because.
You have also questioned that.
Well, I have question is entirety. My fundamental,
This will be against your interest, no? If the entire regulations have been.
no, I said that I have challenged the entire judgment of the honorable single judge
All right.
on entirety. Every reasoning given by the honorable single judge, according to me, is incorrect.
No, no. So far as the amendment is concerned, it is in respect of this co-generation or whatever
Yes,
it is.
yes.
But if the learned single bench has set aside the entirety,
What happens? Can you look at this? The amendment, if amendment goes, then industrial waste remains as a renewable source of energy. So this is
that
the,
is correct. But the stay should be confined only with regard to industrial waste alone.
My lord, that's all, my lord, that I'm asking.
my lord,
Because
That will be proper because
yes,
the issue before the court, from what little we understood,
true.
was because of the amendment which was made to the 2013 notification
True.
in 2020.
True.
According to you, wisdom was because of the tribunal's.
True.
So,
Well,
solar power. The amendment, so you are not aggrieved by wind, solar, or whatever other renewable source.
my lord,
This is only with regard to industrial.
may I say this? May I say this? If lordship restricted to, yes, I understand. Co-generation and the industrial waste, that part, I don't feel agree.
My lord, that's all, my lord.
I
I'm
don't
sorry.
mind. I don't mind. Absolutely.
That's all we need
Yes,
to
yes.
do. Huh?
My lord, in fact, I prepared a
But
to show which
but my
clauses
only,
are solar and which clauses are co-generation.
So far as the interim order is concerned, it will remain in force in so far for industrial waste and co-generation. In other respects,
I'm grateful.
whatever was the regulation prior to
Not prior, my lord, this was
no,
also
the
amended.
prior will create a problem. The
My lord,
prior equals to
no,
industrial waste.
no, whatever was the regulation, excluding in the industrial waste
Yes.
and co-generation,
Yes.
will continue to remain.
Yes.
Yes.
Perfect.
So, my lord, the amendment
Perfect.
had amendments relating to solar energy, had amendments relating to co-generation. Amendments relating to solar energy should remain because, my lord, otherwise the state
So-
falls behind.
Just hear this order. The interim order already granted shall continue. And it stands modified to the extent that the order of interim stay granted will be confined to the amendment made to the regulation. Industrial waste and co-generation.
Yes.
And in other respects, the interim order, the order of stay shall not operate.
My lord,
Other aspects including solar energy, kindly put solar
Other
energy.
aspects, including solar energy, the order of interim stay will not operate.
I'm grateful, my lord. Because my lord,
But I have my only apprehension is that because this has a, my lord, it is otherwise extremely important for the larger aspect. Can I pray for any specific date for this matter?
That is the catch.
I know that is the.
You said that is the catch. This is the catch.
I know that. I know that. My lord, that's a very humbly, because my lord, this is not touching one individual. It has a.
Senior is appearing today.
No. Well, that's the reason, my lord, I'm not asking for any prior. I say any date that lordships. Yes.
We'll fix a date for directions. On that day, we fix a date.
very well.
Let the appeals be listed for directions on 13th July. All whatever affidavits you want to file, you file.
Lord, today I have filed, Lord, an affidavit on behalf of Bengal Energy, affidavit exception to MNRE. Lord,
Affidavit of exception filed by Bengal Energy and
Tata.
affidavit of affidavit in exception filed by Tata, what? Tata Power Company Limited are taken on record. I don't know about my post lunch or what time I'll be able to return. They say from here it will take 1 hour to reach her residence. Let us see. We'll send word.
Lordship may skip today.
Pardon?
1 hour.
No, my lord, kindly don't dismiss today after lunch. Yesterday, 3 matters of mine. One I really wanted to argue before your lordship. My
You
lord, it's
passed
gone.
excellent orders.
No, my lord, my lord, lordship's court practice entirely for my lord. I'm just bemoaning my bad luck, my lord. I couldn't get there on time.
Unless we push, we can't, sir.
No, true.
Unless we push, we can't. Yesterday, 153A matters, it was published in the live law. I said I sent it to my ACO. Anjandari is not here today. He downloaded the judgment. 22 matters yesterday was over. Otherwise, hanging on. And ours is the first High Court which we have followed Supreme. In all other High Courts, is pending. Let's see. Thank you.
Obliged. No.